Hi, welcome to our channel of IGNOU Audiobooks, Indira Gandhi National Open University, School of Law, SOL, Postgraduate Diploma in Intellectual Property Rights, PGDIPR. MIP 105 Copyright and Related Rights. Block-1 Basics of Copyright. Unit-2 Different Rights. 2.1 Introduction. Copyright is not one single right, but a set of rights. It is these rights which make it an intellectual property. These are statutorily created rights. They are not considered natural rights. There are differences in the rights in different countries. However, the international conventions and agreements such as the Berne Convention for the Protection of Literary and Artistic Works, the Universal Copyright Convention and the Agreement on Trade-Related Aspects of Intellectual Property Rights have brought in significant harmony among the rights in different jurisdictions. These conventions provide for certain minimum obligations on the member countries in regard to the rights. The Berne Convention, 1886, which is the first copyright convention, requires member countries to provide for the following rights. 1. Moral rights. A. To claim authorship, and B. To object to certain modifications and other derogatory actions. 2. Economic rights. A. Right of reproduction. B. Translation rights. C. Right of public performance. D. Right of broadcasting and communication to the public. A. Rights of public recitation. F. Rights of adaptation. G. Right to an interest in resale in works of art and manuscripts. H. Right to enforce protected rights. The Universal Copyright Convention, 1952, provides for the following exclusive rights to authors. 1. Right of reproduction. 2. Right of public performance. 3. Right of broadcasting. 4. Right of translation. The TRIPS Agreement, 1994, has referred to the provisions of the Berne Convention and made them obligatory for members of the agreement. It, however, excluded the article relating to moral rights from the obligations under that agreement. Countries who are members of the Berne Convention, however, have to continue to provide for those rights in their domestic legislation. Member countries of each convention have to provide at least for the rights prescribed in the convention concerned. They are, however, free to provide higher level of rights if they so desire. However, the nature of the conventions is such that if a country provides higher rights to its own nationals, it has to provide the same rights to the nationals of other countries who are members of the convention concerned. This is known as national treatment in the TRIPS Agreement. It is the exercise of these rights which guarantee the author moral and economic returns from his work and a powerful incentive for creation. These rights guarantee that someone else cannot claim the fruits of his sweat and labor, and that if anyone wants to use his works for commercial gain, he must take his permission. While granting the license, the author can insist upon certain conditions such as payment of royalty, which guarantees him economic returns. 2.2 Objectives. After reading this unit, you should be able to present the evolution of copyright in international agreements. Describe the various rights that form part of copyrights, and explain the scope of those rights. 2.3 Rights. 2.3.1 Statutory Provisions. 14. Meaning of copyright. For the purposes of this Act, copyright means the exclusive right subject to the provisions of this Act to do or authorize the doing of any of the following acts in respect of a work or any substantial part thereof, namely equals a. In the case of a literary, dramatic or musical work, not being a computer program. I. To reproduce the work in any material form, including the storing of it in any medium by electronic means. E. To issue copies of the work to the public, not being copies already in circulation. E. To perform the work in public, or communicate it to the public. IV. To make any cinematograph, film or sound recording in respect of the work. V. To make any translation of the work. V. To make any adaptation of the work. V. To do, in relation to a translation or an adaptation of the work, any of the acts specified in relation to the work in subclauses I to V. B. In the case of a computer program, equals I. To do any of the acts specified in clause A. 51A. E. To sell or give on commercial rental or offer for sale offer. Commercial rental any copy of the computer program, provided that such commercial rental does not apply in respect of computer programs where the program itself is not the essential object of the rental. C. In the case of an artistic work. OI. To reproduce the work in any material form including a. The storing of it in any medium by electronic or other means. Or B. Depiction in 3 dimensions of a 2-dimensional work, or C. Depiction in 2 dimensions of a 3-dimensional work. To communicate the work to the public. To issue copies of the work to the public not being copies already in circulation. To include the work in any cinematograph film. To make any adaptation of the work. To do in relation to an adaptation of the work any of the acts specified in relation to the work in subclauses I to IV. D. In the case of cinematograph film. I. To make a copy of the film, including a photograph of any image forming part thereof, or B. Storing of it in any medium by electronic or other means. E. To sell or give on commercial rental, or offer for sale or for such rental, any copy of the film. E. To communicate the film to the public. A. In the case of sound recording. I. To make any other sound recording embodying it including the storing of it in any medium by electronic or other means. E. To sell or give on commercial rental, or offer for sale or for such rental, any copy of the sound recording. E. To communicate the sound recording to the public. iOS 57. Author's special rights. R1. Independently of the author's copyright and even after the assignment, either wholly or partially of the said copyright, the author of a work shall have the right a. To claim authorship of the work, and b. To restrain or claim damages in respect of any distortion, mutilation, modification or other act in relation to the said work if such distortion, mutilation, modification or other act would be prejudicial to his honor or reputation, provided that the author shall not have any right to restrain or claim damages in respect of any adaptation of a computer program to which Clause A of subsection 1 of section 52 applies. Explanation equals failure to display a work or to display it to the satisfaction of the author shall not be deemed to be an infringement of the rights conferred by this section. 2. The right conferred upon an author of a work by subsection 1 may be exercised by the legal representatives of the author. 2.3.22 Kinds of rights. As could be seen from the exclusive rights provided in the Berne Convention, there are 2 kinds of rights which form the copyrights. One set of rights is to protect the personality of the author and are referred generally as moral rights. In India, they are referred to as the author's special rights. The other set of rights is what brings economic return to the author. Therefore, they are referred to as economic rights. The term exclusive rights is used because the owner of copyright in a protected work may use the work as he wishes and may exclude others from using it without his authorization. 2.4 Author's special rights. Section 57 of the Copyright Act provides for the special rights of the author. They are independent of the author's copyright and are not transferable. These rights are a. The right to claim authorship of the work, and b. To restrain or claim damages in respect of any distortion, mutilation, modification or other act in relation to the work of the if such distortion, mutilation, modification or other act would be prejudicial to his honor or reputation. This right comes with a caveat that failure to display a work or to display it to the satisfaction of the author shall not be deemed to be an infringement of the special rights of the author. For example, if you buy a painting of a famous author, but just keep it in the store and does not display in your drawing room or anywhere, it will not be an infringement of the rights of the author. Or you may get a sculpture done by a great sculptor, but on completion just keeps it in the basement of your house. It will not be an infringement of this right, as per this provision. There is also a proviso to the section. The proviso is in regard to computer programs. The Copyright Act provides certain exemptions to the rights of the author in the case of computer prography, I1s, which inter alia include adaptation of a computer program by the lawful possessor of a copy of such computer program in order to utilize the computer program for the purpose for which was supplied are to make backup copies purely as a temporary protection against loss, destruction, or damage. Adaptations made under the above case will not be affected by the special rights of the author. Quote dot, comma, comma dot. The special rights of the author can be exercised by his legal representative. Authorship right always remains with the author and cannot be transmitted transferred or assigned. However, if any person wrongly represents the authorship, the legal heir can take action against that person. Dot, comma dot. The special rights of the author in the Indian Copyright Act is based on Article 6 bis of the Berne Convention, which reads, independently of the author's economic rights, and even after the transfer of the said rights, the author shall have the right to claim authorship of the work and to object to any distortion, mutilation, or other modification of, or other derogatory action in relation to the said work, which would be prejudicial to his honor or reputation. The Berne Convention also required the member states to ensure continuance of these rights after the death of the author and at least until the expiry of the copyright and to be exercised by his legal heirs. There are two significant cases which deal with the author's special rights under the Copyright Act. The first one is the case of Manu Bhandari vs. Kala Vikas Pictures, P. Limited. Air 1987 Del 13. This case involved the question of artistic liberty with regard to adaptation of a novel or story to cinematograph film. The High Court looked into the assignment deed between the parties as complementary to Section 57 dealing with special rights of the author. Although, by the time of the judgment the parties had come to an agreement, still the court considered it appropriate to give its opinion, though otiose. But that helped clarify the meaning and significance of the author's special rights in India to a great extent. We will now read the relevant parts of the judgment. The hallmark of any culture is excellence of arts and literature. Quality of creative genius of artists and authors determine the maturity and vitality of any culture. Art needs healthy environment and adequate protection. The protection which law offers is thus not the protection of the artist or author alone. Enrichment of culture is of vital interest to each society. Law protects this social interest. Section 57 of the Copyright Act is one such example of legal protection. Section 57 lifts author's status beyond the material gains of copyright and gives it a special status. Section 57 falls in Chapter XN of the Act concerning civil remedies. Section 55 provides for certain remedies where there is infringement of copyright. Section 56 provides for protection of separate rights comprising the copyright in any work. Then comes Section 57, providing for authors' special rights, and the remedies for violation of those rights. This is a statutory recognition of the intellectual property of the author and special care with which the intellectual property is protected. Under Section 57, the author shall have a right to claim the authorship of the work. He has also a right to restrain the infringement or to claim damages for the infringement. These rights are independent of authors, copyright, and the remedies open to the author under Section 55. In other words, Section 57 confers additional rights on the author of a literary work as compared to the owner of a general copyright. The special protection of the intellectual property is emphasized by the fact that the remedies of a restraint order or damages can be claimed, even after the assignment either wholly or partially of the said copyright. Section 57 thus clearly overrides the terms of the contract of assignment of the copyright. To put it differently, the contract of assignment would be read subject to the provisions of Section 57 and the terms of contract cannot negate the special rights and remedies guaranteed by Section 57. The contract of assignment will have to be so construed as to be consistent with Section 57. The assignee of a copyright cannot claim any rights or immunities based on the contract which are inconsistent with the provisions of Section 57. What is the substance of the protection of special rights guaranteed by Section 57? Subclause A of Clause 1 of the section prohibits any distortion of mutilation of the author's work. The words other modification appearing in the subclause A will have to be rigidum generis with the words distortion and mutilation. The modification should not be so serious that the modified form of the work looks quite different work from the original. Modification, in the sense of the perversion of the original, may amount to distortion or mutilation. But there can be a modification simpliciter such as where A is changed to B, both being quite distinct. Subclause A thus provides inviolability to an intellectual work. Subclause B provides for remedies for protection of honor and reputation of the author. The bundle of rights and remedies provided by Section 57 is in tune with the modern development in law relating to protection of intellectual property of the author and the international agreements and treaties. In that regard, the learned judge is not right in saying that because the modifications are permissible under the contract of assignment, the plaintiff had failed to prove the breach of Section 57. As stated earlier, the correct way of construing the contract of assignment dated the 31st of April 1983 is to read the provisions of the said contract as complementary to Section 57 and not inconsistent with it. Clause B of the contract states, Shri Sirsir Mishra, the director of the aforesaid film, is writing the screenplay of our production. No, I and that you have agreed to allow him to make certain modifications in your novel for the film version in discussion with you to make it suitable for a successful film. Only certain modifications, which are necessary for converting the novel into a film version, are allowed. The second object of modifications is to make the film version suitable for a successful film. But the said modifications are to be done after discussion with the author. The contract further states that proper publicity will be given to the plaintiff as the author of the said story in all credits, commercial and other publicity. Subject to these important caveats, the assignee shall become the exclusive copyright holder of the said novel, to exploit the novel for any reproduction except by way of publication as a novel. Reading the contract with Section 57, it is obvious that modifications which are permissible are such modifications which do not convert the film into an entirely new version from the original novel. The said certain modifications should also not distort or mutilate the original novel. The novel will include the main theme, the situations and the main characters of the novel. The fact that Manu Bhandari is the author of the story is to be published in all the credits. This is for giving due recognition to the reputation of the author. The word credits in the parlance of show business means recognition of credit-worthy actions of all those who have participated in making the show business a success. As a show business or as a box office collection, a film may be a success, but it may do not credit to the reputation or the honor of the author. That is why Section 57 insists on the special protection to honor and reputation of the author. The contract requires that proper publicity should be given. The word proper has to be interpreted in contradiction to notoriety or bad name, causing harm to the honor and reputation of the author. Counsel for the respondent has argued that Clause B of the contract permits modifications to be made by the director. Modifications actually made are made after discussions with the author, and she had a gr.ed to the said modifications. Whether the modifications in the film are within the permissible limits or not will be examined later. Let us first examine the objections of the respondents to issuance of injunction. Counsel for the respondent submits that the restraint order in the nature of injunction under Section 57 can be passed when there is only literary reproduction. If the said novel is published with impermissible changes, the publisher can be restrained, but where the film is produced based on the novel, no restraint order can be passed under Section 57. I do not agree. Section 57 is a special provision for the protection of the special rights of the authors. The object of the section is to put the intellectual property on a higher footing than the normal objects of copyright. The language of Section 57 is of widest amplitude. It cannot be restricted to literary expression only. Visual and audio manifestations are directly covered. The second objection of the respondent is that the author received the balance amount OFRs 10,000 in July 1984, i.e. after she sent the letter of protest to the director, producer. This submission is also without substance. The suit is not for claiming damages but for a permanent injunction. If she accepts part of the consideration, the same is to be treated as acceptance under protest and without prejudice to her rights. The wording of Section 57, viz., even after the assignment, will dispel all doubts on this question. Assignment means passing of the title on payment of consideration. The High Court agreed that some changes are inevitable when a novel is being converted into a motion picture. Outdoor shooting, choosing of sites for that purpose with aesthetic considerations. Situations for the songs, which are a vital part of the Hindi films, are some of the considerations which required changes. So also, selection of situations from the novel for their effective visual presentation should be the choice of the director. However, such changes should not mutilate or distort or completely modify the original theme and characters. The court has, therefore, to balance the artistic treatment of subject by the author and that by the director. What are the objections of the author to the visual presentation of the theme and the characters after seeing the film itself? The first objection of the author is to the name of the film, Samay Ki Dhara. From the correspondence between the parties, it is prima facie clear that she had agreed to this name in desperation, as the matters were not moving. The title, Samay Ki Dhara, is so general as to suggest any social problem that face the Indian society today. For making it more specific, a direct reference to Bunty is necessary. The producer should, therefore, so amend the title as to include in the title, Samay Ki Dhara, and Aapka Bunty. The second objection of the author is to the character of the first husband. In the original story, he is shown as a divisional manager of some company. In the film, he is depicted as an unscrupulous builder. The story in the film shows that he procures work by supplying women. The character of Prakash has been newly introduced in the film as an assistant to the first husband. The novel does not give us any particulars about the character of the first husband. According to the author, he is a normal, middle-class executive. One cannot FMD fault with the director if he partly changes the character in the absence of the specific details in the novel. But the objection of the author is more serious. She submits that the second wife, who, according to the author, is also a simple middle-class housewife, has been depicted as a stereotyped vamp in Hindi films. Her behavior and the expression borders on vulgarity. The author submits that the characters and theme is mutilated through vulgar dialogues. The audiovisual presentation has the object of brash sex to attract box office. I do not agree. If the director wanted to do so, there was full scope to do it from the sequence in the novel itself. The novel depicts that in the new house of the second husband, Bunty is not able to sleep. He sees blue light emerging from the bedroom from the half-closed door. In curiosity, he peeps through the door. He is taken aback by nude figure of the second husband and semi-nude figure of his mother. He is very angry with his mother. But the bare body of man gives new awareness to Bunty of his manhood. He then dreams of several nude bodies and conjures up his place in them. The novel itself provides this episode. If the director wished to exploit it to show more explicit sex sequences, he had the opportunity to do so. This could not have been objected to by the author because it formed part of the novel itself. But the director has, quite sensibly, deleted the whole episode. This submission raises an important question of an aspect of court's powers under Section 57 of the Act. The court does not sit as a sentinel of public morals or super-censor in exercise of its powers under the said section. It cannot impose its views, prudish or liberated, on sex or its depiction in the works of art. The concern of the court is to examine how for the new avatar is true and authentic, and what changes are necessary due to constraints of a medium. The above case tells us how to construe the infringement of the moral rights. It also explains how to examine and interpret the rights of an assignee or licensee in the matter of changes that he considers necessary to adapt a work to a different medium or class of work. Another case that examined the moral rights question is Amarnath Sehgal vs. Union of India, 200530 P.T. C. 253, Del. This case went into the philosophy and justification and implications of authors' special rights as expounded in Section 57 in the background of the international treaties and conventions. Under Article 6 bis of the Berne Convention, the moral right of integrity enables the author to seek appropriate legal remedies if the moral right of attribution and integrity in his work is violated. The moral rights set out in the Berne Convention are significant because they continue to be vested in the author even after he has parted with his economic rights in his work. The right of the author under Article 6 bis of the Berne Convention provides that an author may object to any distortion, mutilation, or modification of his work which is deemed to be prejudicial to his honor or reputation. As formulated in the Berne Convention, vindication of moral rights, being hedged with the precondition of proof of negative impact on the author's reputation, somewhat restricts the span and sweep of the moral right. It is argued by some that where a work is destroyed, since it no longer exists and cannot therefore be viewed by anyone, where is the occasion for prejudice to the author's reputation? Per contra, it could be argued, as indeed was the submission made by learned counsel for the plaintiff, that destruction of a work can prejudice an author's reputation by reducing the volume of his creative corpus. The proponents of the narrow view argue that derogatory treatment of a creative work would mean deletion to, distortion, mutilation, or modification to, or use of the work in a setting which is entirely inappropriate. The opponents of the narrow view would argue that deletion or mutilation is, after all, a treatment of a work, and so is destruction. It is the extreme and ultimate form of mutilation. They argue that mutilation is nothing but destruction so as to render the work imperfect. The mural sculpture decorating Vigyan Bhavan is the result of plaintiff's creative effort. It has not only enhanced plaintiff's celebrity, but has also attained the status of a modern national treasure of India. Authorship is a matter of fact. It is history. Knowledge about authorship not only identifies the creator, it also identifies his contribution to national culture. It also makes possible to understand the course of cultural development in a country. Linked to each other, one flowing out from the other. Right of integrity ultimately contributes to the overall integrity of the cultural domain of a nation. Language of Section 57 does not exclude the right of integrity in relation to cultural heritage. The cultural heritage would include the artist whose creativity and ingenuity is amongst the valuable cultural resources of a nation. Through the telescope of Section 57, it is possible to legally protect the cultural heritage of India through the moral rights of the artist. The court approvingly quoted the opinion of Mirati Sundara Rajan in an article published in the International Journal of Cultural Property, Vol. LO number 1200 IPP 79-94 under the title Moral Rights and the Protection of Cultural Heritage. The rights of attribution and integrity are particularly apposite to the cultural domain. Apart from the interests of individual authors in maintaining their standing and reputation, these moral rights are closely linked to a public interest in the maintenance of historical truth and cultural knowledge. Moral rights also promote the development of a social attitude of respect toward individual creativity. While authors must accept the responsibilities which accompany the privileges of creative work, is incumbent upon both the public and the state to acknowledge the value of artists' contributions to cultural heritage. The court then looked into the policy approach of the government towards culture and culture rights as expounded in various official documents such as the 5-year plan document. It also examined various international conventions on the protection and preservation of cultural patrimony such as the Convention on the means of prohibiting and preventing the illicit import, export and transfer of ownership of cultural property, the Declaration of the Principles of International Cultural Cooperation proclaimed by the General Conference of the United Nations Educational, Scientific and Cultural Organization, and the UNIDROIT Convention on Stolen or Illegally Exported Cultural Objects. It then interpreted Section 57 in a wide sense, keeping in view these international agreements. There would therefore be urgent need to interpret Section 57 of the Copyright Act, 1957 in its wider amplitude to include destruction of a work of art, being the extreme form of mutilation, since by reducing the volume of the author's creative corpus it affects his reputation prejudicially as being actionable under said section. Further, in relation to the work of an author, subject to the work attaining the status of a modern national treasure, the right would include in action to protect the integrity of the work in relation to the cultural heritage of the nation. It is held that the plaintiff has a cause to maintain an action under Section 57 of the Copyright Act, 1957, notwithstanding that the copyright in the mural stands vested in the defendants. It is further held that the defendants have not only violated the plaintiff's moral right of integrity in the mural but have also violated the integrity of the work in relation to the cultural heritage of the nation. The above two cases tell us how the courts are viewing the moral rights of authors. They perceive them as ways to protect the cultural integrity of the country. They also interpret the section in the context of the international efforts to protect cultural patrimony. 2.5 Economic rights. The Copyright Act does not refer to the various rights it provides the author as economic rights. In fact, the rights are provided in the explanation of the meaning of copyright. They differ with category of works. The largest numbers of rights are for literary, dramatic, and musical works. 2.6 Rights in literary, dramatic, and musical works. The author of a literary, dramatic, or musical work has the following rights: A. To reproduce. B. To issue copies of the book to the public, not being copies already in circulation. C. To perform the work in public, or to communicate it to the public. D. To make any cinematograph, film, or sound recording in respect of his work. A. To make any translation of the work. F. To make any adaptation of the work, and G. To do in relation to a translation or an adaptation of the work. Any of the above acts. The right of reproduction is the basic right which prohibits any other person from copying a work in material form without the permission of the author or owner of the copyright. The most common form of reproduction is printing of copies of a book. The main form of piracy of books is this. Even making manuscript copies is also part of right of reproduction, since there is a reproduction of the original in a material form. The Act clarifies that storing of the work in any medium by electronic means is also part of the right of reproduction. This takes care of the digital copies as well as copies being made on the internet. 2.6.1 Right of distribution. The Copyright Act gives a separate right of issuing copies of the work to the public. This is the right of distribution. It is, however, made clear in the law that copies already in circulation are not affected by this right. That means the right exhausts on first sale. That is to say, if you have bought a copy of a book, your selling the copy to another person is not restricted by this right. 1. L. J. 2.6.2 Right of communication to the public. Reproduction and distribution of a work in a material form is only of the means to make access to a work. For example, a drama can be performed on the stage, which does not involve any reproduction in any material form or issue of copies of the work to the public. At the same time, the interests of the author are affected. Therefore, the Copyright Act provides a specific right of performance of the work in public. It also specifically states as the right of the author to communicate the work to the public. For example, a book cannot be read over the radio without the permission of the copyright owner, if it is within the copyright regime. 2.6.3 Right to make a cinematograph, film, or a sound recording. In line with the advancement of technology which made possible making of cinemas and sound recording, the Copyright Act provides that the right to make the work into a cinematograph, film, or record in a soundtrack is with the author or owner of the copyright. For example, if you have written a story, a producer cannot use that story to make a cinematograph film, though it may not exactly being materially copying the work. Similarly, a sound recording of it also cannot be made. The terms cinematograph, film, and sound recording cover all the electronic means of making video or audio recordings. 2.6.4 Translation right. The copyright law gives the right to translate a work into another language also to the author. Therefore, if a work in which copyright subsists is in Hindi, it cannot be translated into English without the permission of the author. Once Translated, the translated version also enjoys all the rights which were on the original work. For example, if the aforesaid English translation is to be translated into French, then the person who wants to translate should take the permission of both the original author as well as the translator. Similar is the case if a cinematograph film is to be made based on the English translation. 2.6.5 Adaptation right. Different rights. Quote. The scope of the right of adaptation extends to conversion of a dramatic work into a non-dramatic one, conversion of a literary or artistic work into a dramatic work, any abridgment of a literary or dramatic work in which the story or action is conveyed wholly or mainly by means of pictures in a form suitable for reproduction in a book, or in a newspaper, magazine or similar periodical, any arrangement or transcription of a musical work, and also any use of a work involving its rearrangement or alteration. It covers the right to make simple adaptations of a book to suit specific needs and requirements. In this case, there is no substantial reproduction of the book, since the adapter or abridger may be using his own language, but he needs the permission of the author. The adapted version also enjoys the same rights, just like the translated version. 2.6.6 Special rights for computer programs. The author of a computer program enjoys all the rights that are bestowed on the author of a literary work. In addition, he enjoys the right to sell give on commercial rental of the computer program. While literary works can be issued to its members by a lending library, a computer program cannot be issued without specific permission of the copyright owner. However, the right does not apply in a case where the program itself is not the essential object of the rental. For example, a car may have many computer programs in it, but when a person hires a car, he does not require any separate authorization for using those programs which are inbuilt in the car, since the programs are not the essential objects of his hire but the transport vehicle. 2.7 Rights in an artistic work. The author of an artistic work enjoys almost all the exclusive rights that the author of a literary work except the ones on translation and sound recording. The reproduction right in the case of an artistic work covers the reproduction or depiction in 3 dimensions of a 2-dimensional work or in 2 dimensions of a 3-dimensional work. However, the Act at present does not make specific clarification that reproduction in the digital format is within the ambit of this right. 2.8 Rights in a cinematograph film. The reproduction right in a cinematograph film is the right to make a copy of the film. It, however, has a wider scope in that making a photograph of any image forming part of the film is also within the ambit of that right. As in the case of a computer program, a cinematograph film also enjoys the commercial rental rights. 2.9 Rights in a sound recording. Quote. The rights in a sound recording are by and large similar to the rights in a cinematograph film. In this case, the reproduction right means making any other sound recording embodying the work in the sound recording. It also enjoys the rental rights like a cinematograph film. 2.10 Resale share rights. The Copyright Act contains a special provision for original copy of a painting, sculpture or drawing or of the original manuscript of a literary or dramatic or musical work. If such a copy is sold for a price exceeding 10,000 rupees, the author has a right to a share in the resale price of the work or manuscript. This right will exist with the author even after assignment of the copyright in the work to another person. This right is only in the case of works of which, as per the provisions of the Act, the author is the first owner. For example, if it is a painting drawn for valuable consideration under the instance of another person, the author shall not have any resale share right. This right also will cease to exist on the expiry of the copyright. The share is to be fixed by the Copyright Board, but it shall not exceed 10% of the resale price. The Indian Copyright Act follows the international conventions in regard to the rights it grants to copyrighted works. It also takes note of the technological advancements in the areas and has provisions which cover digital copies. Case laws. The meaning of reproduction or copy came up in the case of Star India P. Limited versus Leo Burnett India P. Limited 2003-27 P.T. C81 born, though in the context of a cinematograph film. After quoting the definition of copy from the Oxford English Dictionary and the definition of infringing copy in the Copyright Act, the court looked into Copinger and Scone James on Copyright 13th edition, at paragraph 3.29 and reproduced the following portions from that book. It has been stated that skill, labor and judgment merely in the process of copying cannot confer originality, and the mere copyist cannot have protection of his copy, particularly, therefore, where the reproduction is in the same medium as the original. There must be more than an exact reproduction to secure copyright. There must be some element of material alteration or embellishment which suffices to make the totality of the work an original work. If the original, in the case of a painting, is used merely as a model to give the idea of the new work, or, in the case of a photograph, merely as a basis to be worked up by photographic process to something different, then the network may be entitled to protection, but, if the result is simply a slavish copy, it will not protected. The same authors in the 14th edition in paragraph 7.98 have dealt with films. The learned authors have stated as under: it is an infringement of the copyright in a film to make a copy of it, or a substantial part of it, whether directly or indirectly, and whether transiently or incidental to some other use. This includes making a photograph of the whole or any substantial part of any image forming part of the film. As with a sound recording, it is not expressly stated that copying of a film includes storing it by electronic means. But again, it is suggested that it does. Again, the copyright in a film is infringed if the recorded moving images are directly or indirectly copied, but not if the same or similar images are recorded independently, for example by reshooting the subject matter of the film. Again, however, underlying works such as the screenplay may be infringed by such means. Quote. As pointed earlier, contrasting section 14, D, and A, on the one hand, and section 14, A, B, and C, on the other, in the latter case the owner of the copyright has exclusive right to reproduce the work in any material form. This is absent and excluded insofar as the former case, cinematograph film, sound recording. The exclusive right in the former is to copy the recording of a particular film, sound recording. It is, therefore, clear that production by another person of even the same cinematographic film does not constitute infringement of a copyright in a cinematograph film. It is only when actual copy is made of a film by a cess of duplication, i.e., by using mechanical contrivance, that it falls under section 14 D, I. The expression, to make a copy of the film, would mean to make a physical copy of the film itself and not in another film which merely resembles the film. The making of another film is not included under section 14 D, I, and such other film, even though it resembles completely the copyrighted film, does not fall within the expression, to make a copy of the film. Therefore, if the film has been filmed or shot separately by a person and it resembles the earlier film, the subsequent film is not a copy of the first film and, therefore, does not amount to infringement of whole of the copyright of the first film.